Welcome to the Meaningful Mediation podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. Welcome to the Meaningful Mediation podcast. I'm your host, Patrick Russell, and today we're exploring the art of negotiation from a perspective that you usually don't hear. The front lines of international trade law and high-stakes criminal defense. My guest today has spent over 3 decades navigating the most complex corners of international commerce, which includes customs seizures, FDA investigations, grand juries, trade-based money laundering, and white-collar criminal defense. He has stood between his clients and federal prosecution more times than most lawyers can count, and he has won. He is the founder and principal of Becerra Law, based in Coral Gables. He is one of approximately 50 attorneys in the entire state of Florida who hold board certification in international law from the Florida Bar. He is AV preeminent rated, a perennial Florida super lawyer, and named to Best Lawyers in America and featured in the 2026 Chambers and Partners Florida Spotlight for International Trade Law. On top of all that, he is currently a candidate for the Florida Board of Governors for the Florida Bar. Bob, welcome to the Meaningful Mediation podcast. How you doing?
Good. Thank you, Patrick, for having me. I appreciate it very much.
Okay, well, glad that you could join us. So, Bob, let's start at the beginning. I really kind of want to understand the journey that brought you here. So, you spent, I believe, your early years of your legal practice at Sandler, Travis, and Rosenberg, right? One of these leading international trade law firms.
That's true. I mean, I ended up getting into international trade law through a pretty long journey. Before I was a lawyer, I was actually a export manager at what they called an export management company, which is a company that handles the international sales for like a U.S. company that wants to export its products. I went to law school. I caught the litigation bug. But because of, my past background, and because I started doing criminal defense here in Miami, which often had international trade implications, I ended up specializing in international trade law. And I went to Sandler, Travis, and Rosenberg, which was one of the leading U.S. firms in international trade law. I headed their white-collar crime department, and I did a lot of their other civil litigation as well. And I've just that's been my niche, so to speak. Miami's a competitive legal market. And so I thought I'd better specialize in something, something that's niche-y. And that's where I also decided to pursue and achieve Florida Bar Board certification in international law as well.
Excellent. And what did your early years of your legal practice teach you about how to negotiate with the government?
Well, with the government, they have different motivations, unlike private litigants. So, for instance, sometimes, the reason why a investigation or a criminal case was being pursued would be there would be a political implication to it. For instance, like right now, the government looks into people evading sanctions, like selling things to the Russians. And there are a lot of sanctions because of the Ukraine war. So those investigations or criminal cases brought because of them have political implications, and that's why that generates that activity. So I learned very early on that sometimes, whether it was the drug war in the old days, where that seemed to be the number one, even though it's a high priority now, it was, then Miami was the number one, was really the only priority for a while. And then it went to frauds and Medicare frauds. And it would be that the flavor of the year is that this year they were really going to go after Medicare fraudsters. Next year it could be, people who do credit card frauds. And so it really, you learn that where the cases were going to come from was really a decision ultimately probably made in Washington by a politician. And then, the prosecutors got their marching orders and the agents, FBI, whatever, and that's where they were going to put their resources. So from that standpoint, it was a much different practice than just litigating against private parties. In business cases, it's normally about the money. Or, and if it's not about the money, it might be prospectively about intellectual property rights or, things like that, in order to make sure that companies are able to exploit certain markets. So it was a very different standpoint from the very beginning. And also from the government standpoint, right? They're being funded by the taxpayer. So, they don't have to go back to their client and say, hey, you need to replenish the retainer. Right? Like you would in a private litigation or even, if you're doing contingency fee, if you have a plaintiff doing contingency fee, he has credit lines and things like that. And the government doesn't worry about stuff. They're funded. And so, to tell them, boy, this case is going to be really expensive for you to try is just not an appealable argument, for them to negotiate and settle. I mean, they don't care. I mean, the lawyers are getting paid a salary, whether they resolve the case or not.
For sure. And then eventually you open up your own shop, so Becerra Law.
Right.
And
Yeah, go ahead.
walk us through that decision. Why did you end up doing that?
Well, given that I was in a niche practice, I learned more and more. Being part of a law firm for me was of limited utility. And I'd been part of, I left Sandler, Travis, and Rosenberg because, I decided I, wanted a different environment and have a more litigation. That firm did a lot of international trade law, but a lot of non-litigation international trade law. I wanted the more litigation focused firm. So I went to a couple of different firms first, but discovered that really I was sort of like an island in that, I wasn't really getting a lot of cross pollination of cases from those firms. And because of that, it was really all I'm doing is sharing overhead. And so I decided, well, I can do this on my own and have the same amount of work. And so that's what I did. That was really the choice there, to be independent and because the law firm model just wasn't advantageous really for my niche practice.
And you mentioned earlier your board certification. Um, why did you pursue that, and how does that change how clients and courts may perceive you?
One of the reasons I decided to pursue that was once again because I was sort of that island, that niche when I was in these law firms, and so around the time I was coming to the conclusion I was going to go out on my own, I said, well, I wanted to distinguish myself from others. Only a small percentage of the total Florida bar are board certified lawyers of anything. I mean, there's like 30 different disciplines you can get board certified in. International law was one. I was already practicing international law, international trade law, international criminal law, things like that nature. And, basically, since then and to this day, there are no more than 50 in the entire state that are board certified. And therefore, I could tell clients or prospective clients that, hey, don't listen to me when I say I know what I'm doing. The Florida bar says that I'm an expert in this field of law. So you don't have to believe me. Don't have to believe my advertising or my website or whatever. The organization that regulates lawyers says I'm an expert. And one thing you can do as a board certified lawyer, you have a different title. In other words, I sign my stuff Robert J. Becerra, BCS, as opposed to ESQ. BCS is Board Certified Specialist, and that's an official title granted by the Florida Bar only to board certified lawyers. So if you see a lawyer that's got that title behind his name, you're dealing with a board certified lawyer, and it's a very rigorous process to get board certified to stand with. And so I think it's a great program, and I encourage any lawyer that is eligible to pursue it.
Fantastic advice. And there's what, over 100,000 lawyers, and you're one of 50 in your specialty. That's pretty significant.
Yeah, and it's a great selling point. It's a very, to clients, it's a, it's a great credential to have. You get sought out for the advice because people know, well, the bar says he's an expert. He must know what he's talking about. And that goes for all sorts of disciplines. There's, board certifications in business litigation, civil trial law, admiralty law. I mean, you could go on and on. There's entertainment law or sports law or something like that, intellectual property law. I mean, so there are a number of different disciplines, and so board certification. At least you're dealing with a lawyer that had to pass a rigorous process to get that title.
Yep. I wish the bar would have a certification for neutrals, so in dispute resolution. But from what I understand, they do not consider what we do to be the practice of law. So it's going to be impossible to get that type of a certification. But that's for another story.
What's
Um,
funny about that, Patrick, is that there is a certification in international arbitration, litigation and arbitration. So, for instance, if you're an arbitrator, I mean, do you think maybe that that
as
certification
an
can
advocate,
apply, right? I mean, that kind of thing. So it's interesting, how the bar, labels and classifies different practices.
yes. So one of the things that stands out about you on your website is that you've conveyed that on multiple occasions you have convinced federal law enforcement not to file charges against your clients by preparing what you describe as a persuasive presentation, which is pretty amazing. So, can you walk us through what that actually looks like? What goes into making that type of a case to a federal prosecutor?
Very often, well, dealing with the government, number one of their biggest the things that they are interested in is, do they have a winnable case? Can they prove the guilt of the defendant beyond a reasonable doubt? So very often, there's two ways you attack investigations when you need to make a presentation. Sometimes you don't need to make a presentation. Sometimes they do an investigation and there's just no evidence, right? Other times, there may be evidence against your client, but is it really sufficient evidence that the prosecutor should go to trial with? Or number two, is there a policy or political reason why the case shouldn't be looked at as well? So sometimes, give me an idea, sometimes it is persuasive to law enforcement to present them, even though they won't admit they find them persuasive. But lie detection evidence is completely inadmissible in court. Can't use it in court. But law enforcement themselves use lie detectors all the time. They test their own informants with it, and they use it all the time. So in a presentation that's not going to court, it's just with the prosecutor. If there's some, a specific salient issue that is the crux of the case, that you can test on a lie detector, sometimes having your client sit for a polygraph can be very persuasive, and along with other evidentiary factors you give them, why you'll have trouble proving this, you'll have trouble proving that. And by the way, my client passed a polygraph on the central issue in the case. And a lot of times they'll come, they'll either decide not to pursue charges at all, or, sometimes, depending on the kind of case it is, there are lots of cases that, carry civil penalties along with criminal penalties. That's often in the trade context. An intentional violation of a customs regulation or statute is a felony. A stupid violation of a customs or trade statute or regulation is, you can get a civil penalty for that. And sometimes the victory is just to convince the prosecutor, this isn't a criminal matter, it's a civil matter, let it go. And that happens as well sometimes in more complicated white collar cases when you're dealing with state law enforcement. The victory said, look, this is really just a business dispute between two people. It's not really a fraud. I mean, the other side says you lied to them, but did we really, or is it just business? Or, and a lot of times, overworked state prosecutors or state law enforcement, their eyes will start going swimming in their heads and they'll just tell you, this sounds like a civil matter. And you go, you're right, it is. And then, your client on the other side, they can knock themselves out in civil court. and that's okay. But at least you don't have to worry about law enforcement, coming down. And a lot of times, the other side tries to get an advantage that way. They report, they sue your client, and at the same time make a presentation themselves to law enforcement to try to get your client prosecuted. And so, and they do that because, oh my God, number one, if I might get prosecuted, I sure don't want to say anything in a civil case that could be used in the criminal case. So you're fighting sometimes parallel proceedings, and sometimes it's a huge victory to get criminal authorities out of the way, because then, you don't have self-incrimination issues and things of that nature. And your client doesn't have to worry about, am I going to go to jail, or am I just cutting a check to the other side? And, they always would rather cut a check.
Yeah. Yeah, I've heard that phrase. You mentioned the word stupid, and I always chuckle when I heard this phrase. I don't know if you've heard this before. Do stupid things and get stupid prizes. And I always thought that was an interesting way to convey that idea. Uh, um,
I always say it's, sometimes you talk to your client and to them it's counterintuitive. I don't want to say I did anything wrong, or did everything properly. And I understand that, because, it's, to your own shareholders, it's not a great defense to say, well, two things happened. I either intentionally violated the law or I was incompetent. That's not exactly a ringing, endorsement to your shareholders or board, or to make, that pitch. But if it gets you out of criminal charges, you'll do it. But some people won't. That's why you normally see those in political cases, like with Congress people. They have them almost dead to rights. But they won't admit that they did something stupidly, because, oh my God, next election, that's number one, so-and-so admits he's an idiot, and you lose an election. You see that a lot with the Epstein stuff, they're having issues now. He has, yeah, I didn't really know him, but you were at the island, so,
hmm.
nobody wants to admit I was there, even though, it's clearly that you were, because it's an awful thing to have to admit, because of all the innuendos, whether you did anything wrong or not.
So, trade-based money laundering is one of your specialties, and South Florida is, as you wrote in the Daily Business Review, in the bullseye. So, for people who don't know this area, what makes these cases so uniquely complex from a negotiation standpoint?
Well, trade-based money laundering in South Florida is a very, very, very big issue. You watched in the old, like, Scarface movies and things like that, that the way drug dealers launder money is by bringing duffel bags of cash into banks. It's not really the way they do it. They become much more sophisticated, and what they do is they invest in businesses, and they sell and buy product, and they flood those transactions and supply chains with dirty money. And it's very hard to detect the money laundering, because it's under the cover of what appeared to be out on the outside very legitimate transactions. You could be selling computers, you could be selling cars, you could be selling cell phones, all sorts of things like that. And so it's those are challenging cases from that standpoint, because very often your client is doing a lot of what the government says they are. In other words, the government says your clients are selling cell phones to people in Latin America. Yeah, absolutely. That's what I do for a living. Okay. The people in Latin America, we think, are paying for these phones you're selling them with monies that we believe we've traced to a cartel. And your client's normally like, what are you talking about? How am I supposed to know some guy in Argentina is sending me wire transfers from some bank account that you said the money that was in that bank account came from another bank account that came from another bank account that went to the Sinaloa cartel, right? So from a negotiation standpoint, a lot of times you start off and you tell the government, hey, my client's a legitimate cell phone exporter, and this is how he does business. And they go, yep, that's how he does business. But he's getting paid with dirty money. And I
Mm.
said, yeah, okay, well, how is he supposed to know that any of these wires were traceable. I mean, clients are not the FBI, and they're not Homeland Security. And a lot of the companies that are engaged in this, they're small businesses too. It's not like, it's one thing if General Electric with 500 people in the compliance department takes dirty money, but if it's you and, Abuelita and Primo Jose, it's a little different analysis. So a lot of times their negotiation there is going to be that under the circumstances, your client did sufficient due diligence that a reasonable person would never have known they were receiving monies from an illicit source. And these are very fluid cases. I mean, if they take your money, you're entitled to trial, whether it's in state or in federal court, depending on the seizing agency. You're entitled to jury trial. And so, it all, determines, what are the risks once again to the government. They want the money. A lot of this is money based. So I always laugh in that I've had cases where the government says, we think your client was paid with drug money. Oh my God, that's horrible. But I think you're wrong and I'm going to fight this. Well, how about we settle this? We give you half the money back. And I'm saying, okay, well, you just told me my client got paid with drug money and you're going to give my client half the drug money back. Is that what you're telling me? And they'll say yes. And so that gives you an idea is ultimately what the real incentive for them. They want, money, then, these monies go to supplement their budgets and things of that nature. So often there's a couple problems with the negotiation. Again, you're going against a litigant with unlimited resources. Your client doesn't. They've had their account seized already. Now they have to pay you more money to fight the government and try to get it back. And very often, unless it's completely frivolous case, it's very difficult to get attorney's fees against the government in these kinds of cases. And so those are the issues for, negotiation. Can you show that you're an innocent owner? Great. Do you have the staying power to fight a jury trial against the government regarding your money when probably they're willing to settle with you for something beforehand, whether this money was drug money or not? They'll just say, we'll give you some of the money back. Well, gee, I don't think it's drug money. Well, we think it might be. And so their burden to seize your money basically is probable cause. It's a very low standard of proof. But at the same time, they know we can seize your money. You need your money. They don't. What are you going to do next? And so that's what makes those cases particularly challenging, and why most of them settle before they get to trial. It's just because that it's already a financial disaster for your client already. And, then he looks at, well, I'm going to put good money after bad, even if I win, it makes it a very difficult kind of case. And that's why there have been all sorts of abuses to that process. It's called civil forfeiture that have been documented. And because, the system allows seizures on very little evidence. The cases end up taking a long time. The claimants to the money don't have the resources to do what's necessary to try to get it back, even if they think that the cases are meritless. And that makes it very, very, very challenging. And those cases are normally not mediated. The government has an exception to the normal, order of mediation in those kinds of cases.
And how long would a typical case like that take if it had to go to trial?
Yeah, I mean, we're talking about a regular federal civil case and a state civil case, the same thing. Basically, actually in the state of Florida, in state court, you have actually a lot more rights in fighting these kinds of cases than you do in federal court. And what I mean by that, in state court, you have the right to an adversarial preliminary hearing very quickly. But that's only to determine whether the state had probable cause to seize your money. And, that's a low standard. So they win the vast majority of
And
those.
the probable cause is not necessarily what your client did, it's what they think
The money.
somebody else did.
Right, right, right. And that's what, the probable cause could be simply, well, Agent so and so from New York Task Force is willing to testify that in his opinion, from his many years of investigative experience, he knows that currency markets in Paraguay, where you've been selling, have lots of drug money in them. And they believe that these bank accounts that you got money from probably, right? Probable cause, probably had drug money in them as well. And judges will normally say, well, probable cause, not a whole lot. There's not a lot. For instance, probable cause is what you need for a search warrant. And I'm not aware of it. You never hear judges saying, I'm not signing that search warrant. I mean, they signed the search warrant, right? Just as long as you put something in an affidavit that looks reasonable, right? Looks like probable cause. I mean, your money gets seized. But if you take the case to trial, there's a jury trial, you're talking about the same thing: depositions, interrogatories, requests for production, potentially summary judgment, depending on what the discovery showed. And, in the average case, you're talking a year. I mean, if the case moves, you're talking a year.
And that is very devastating for a small business if all their
Sure,
money was seized.
sure, sure. A lot
Wow.
of times they're seizing the company's operating account. So the owner's coming out of his own pocket, to try to, it's very challenging.
Well, I call this next section here the defining moment. So, Bob, I'd like you to take me through to a specific moment in your career, whether it was a case, a negotiation, something that fundamentally changed how you approach your work. Doesn't have to be the most famous case, or sometimes the quieter ones teach you the most, but something that really set off a light bulb and put you on a path. What would that be?
Yeah, I mean, for me, I started my practice in criminal defense, and the same thing, has held with me since then. Is that especially with large, whether it's a defendant, whether it's the government, is that is that you need to put them to their proof. I mean, and the reason I say that, I've had cases where, I mean, it looked horrible, probable cause, all this kind of stuff. And when we got down to trial, where admissible evidence had to be presented, a lot of times they just don't really have it. A lot of it is hearsay, or they have authenticity problems. All of these things that, if you know the rules of evidence, are can be almost insurmountable in certain international cases. If all your information is based on a witness that's in Chile, well, they better be able to bring that witness from Chile to testify, and a lot of times they can't. So that's why, if you don't, if your client has the wherewithal to be able to litigate the case. And I say a lot of them don't. They just don't. But if they do, you can beat a lot of these cases by knowing your rules of evidence and being able to eliminate. I just got over a trial recently I mean, we settled the case during jury selection right after an in limine hearing. And basically, the other side was going to make their case with a bunch of emails. The emails were from third parties, and whether the emails were even hearsay or not, he didn't have a witness to authenticate any of them, and the judge excluded their case.
Mm.
The case ended right then and there, right? But but had to go all the way, had to go to trial, where the judge finally made a ruling in limine that, well, that's not admissible. That's not the Florida evidence code. And sometimes you get a lot of lawyers that have now been schooled in the arbitration world, and in arbitration, the rules of evidence don't apply. So they're not used to, you need to bring in the witness. How do I know he really wrote this email? He needs to testify to that. You can't just, some people think that emails by themselves, if you keep them in your email system, that's now an admissible business record. And it's not an admissible business. It's an admissible business record if you created the email, you created it, or a record you created. But if somebody else sends you a record they created and all you're doing is archiving it in your system, it doesn't automatically become an admissible business record under the business records hearsay exception. And I've won a few cases just on those kinds of things where, the plaintiff's evidence was just emasculated because none of it was admissible, and they had no idea. They were like, they didn't understand. They argued how it was business record, and at the end of the day, judge goes, "Hey, sorry." I mean, that's not the way the rules of evidence work. And that's what taught me very early on in my criminal defense practice, putting the government to its proof, and then in the civil cases, doing the same, putting them to the proof. They'll do a lot of things in discovery. But as we know, things in discovery don't need to be admissible. They're just discovery. But now when we're going to have a trial now. Well, okay, you got that email. That looks like a great email for you. Okay, where's the witness that's going to testify that really is the email? And they're like, what? And that's what my main thing was, is that what happens is that a lot of people, because they don't do a lot of trials anymore, they lose that skill, that even that analysis of what is an admissible document or not. I was, I laugh, but it's not really funny, is that, during the 2020 election, Donald Trump brought like 65 lawsuits to try to invalidate the 2020, and almost all of them were thrown out on standing or evidence issues. They came in and said, Joe told Jill that told so-and-so that they saw a video somewhere that said a guy had a duffel bag full of ballots, that they were, and that was the kind of evidence they were trying to present in court to invalidate the 2020 election. They all got thrown out, because that's not evidence. And because of that, I encourage clients to, when you think you have a case that's really going to go all the way in court, to make sure, the lawyer has, knowledge about how to do that, how to put things into evidence and how to defend against inadmissible evidence.
Well, thank you for sharing that. So, from what I gathered, it's know your rules. Your early case, your early career taught you know the rules.
Exactly.
Well, let's shift to another segment that covers what I would call the negotiator's toolkit. So, from your perspective, what would be your go to strategy for negotiation in what you do? What's like the single most important thing?
And the single most important thing, I think, especially going into mediation, is understanding the damages portion of the case. Liability you can fight about to and from, but at the end of the day, not only do you need liability, you need damages to win cases. And obviously the plaintiff is going to be interested in winning damages, not just, you have cases where, they want to make a point, right? Right. Where, and if they're
Principle.
on principle, if they're rich enough to do it, it's great. Right. But ultimately it comes, can I win the case? So it really drilling down into the, once again, it goes into proof. Right. It is, in a mediation saying, look, I mean, okay, you say it's $1 million. Okay. I looked at your discovery on, discovery took on damages, and how are you proving any of it? How is this not speculative? How does this not get thrown out? Or your expert witness is, has very little experience in this area. And, or if you have your own expert who's, told you that maybe their valuation model's faulty or something, or a lot of times, they just put together a future lost profits model that's just complete speculation. And from there, I mean, if you can convince the other side, or convince the other side's lawyer that there's really a problem there, that gives them quite an incentive to at least mediate reasonably. And then you can come to a conclusion as to, whether you're able to settle the case in an acceptable basis. But there are a lot of people come in with high damage numbers, and then and then at the end of the day, what's going to, how is it provable? Yeah, how are these numbers provable? Put out a big number here, but it's complete speculation. Speculative damages are not admissible. And so I usually start from, really studying on the, if I'm defending on that point. On the plaintiff side, I do mostly more defense work than plaintiff work. But on the plaintiff side, there is, you need to know what your damages are. I mean, to the extent you're doing a business case where your damages are much more ascertainable. In other words, you're not looking for future lost profits where, you normally would need an expert witness to come up with a model as to what that is. But you're just saying somebody didn't pay my invoice. Well, that's much easier. Your damages that's the invoice and you didn't pay me. Normally the defenses have to do more with, was there really a contract in the first place? Was there fraud in, in the inducement? Was there, is there a set off? Those kinds of things. And so, just knowing, understanding the defenses are there and whether there are personal issues. Sometimes even between businessmen, the two parties hate each other personally. They just, they've been competitors for years and they just personally, they'd rather go down fighting than give how many times I've heard, Bob, I'd rather pay you than pay that son of a beat. Right. That kind of thing. I'm telling him, hey, look, we can settle this case for something that would, I'm telling them that if we went to trial, we could settle this case right now for something probably less than what a trial is going to cost you. I'd rather pay you, Bob, than pay that bastard, or something like that. And so you got to be aware of those issues and personal issues, and then try to address them. How do we get around that? Sometimes you get around that, by barter arrangements. I mean, something where, it's, you have to try to be creative, and come sometimes with non-monetary terms that mean something to the other side. I've done ones where, they were just pissed off and I'm not paying him a dime. I said, okay, you're not going to pay him a dime. How about this? If he'll settle the case in return for you, shipping, 2 containers of goods for free. You're not paying him anything. You're just going to ship 2 containers. That ended up being more palatable to the guy. Right? I mean, to me, it was, 6 of one, half a dozen of the other. But the fact that he didn't make a payment was important to him. And so, you have those kinds of, those idiosyncrasies that are important to understand, and also to manage your client's expectations. There's so many people that, they're sophisticated in business, but not sophisticated in litigation. And they're just like, well, let's just sue him. Like all of a sudden, I'm going to sue this guy. He's going to pay you a big wad of money, and the case is going to be over in a week.
Yeah, magically.
Yeah, I mean, they've been watching too much television, right? I mean, and they said that's not the way this works. I mean, I remember I represented many, many years ago a prominent real estate developer in New Jersey, and it was a civil case. And basically, I mean, what he told me, and I think it's the Donald Trump version of life, is that, if people aren't suing you regularly, you're not a player.
Oh,
yeah, that's what, I mean, this guy really, he owned most of the real estate under northern New Jersey. I mean, that's how much, all those towns in northern New Jersey that were developed after the war, he was like the developer. And basically that was his thing. Hey, that's part of business. You get sued, you sue. I mean, and it's just like, like I said, look, with the president, the current president is, litigation is just another business strategy. While there are many other people who are getting sued, it freaks them out. Oh my God, I got sued. They have palpitations in their nerve and they're calling you at 1 o'clock in the morning and, hey, relax. I mean, the most inefficient and slowest way to solve anything is involving the court system, right? That's not the way to solve things efficiently. And, but it all depends on your sophistication with these kinds of things.
So, given what you just said, are you a proponent for mediation and as a possible source of that pain, eliminating that pain?
Yeah, yeah. The whole thing for me, just strategically, is really, I mean, cases have to mediate, right? If they're filed. The whole question really is, when should it happen,
Mhm.
right? Because I mean, you can do, if you follow like the normal court case management order, I mean, mediation is going to happen way down the road when you've already done tons of discovery, you've spent a lot of money on your lawyer, maybe money on expert, and all of that kind of stuff. Well, if you're able to mediate in the beginning, if there are reasonable people, maybe you can come to a settlement where everybody's not now really pissed off at each other because of
And
the
entrenched, right?
right. You're entrenched. You went through depositions. I spent all this money, all of this kind of stuff. You say, I might as well go the whole way. So sometimes I think maybe the rules of procedure or just not procedure, but just maybe, the rules of the circuit, like, the chief judge issue an administrative order that maybe there should be a short mediation in the beginning of cases, like maybe after the filing of an answer. And, and before you can commence discuss, I even better. Now that the rules provide in state court that you have to do initial disclosures, right? We didn't have that a year ago, more than a year ago. Now you got to do that. So right after submission of initial disclosures, which happen in the very beginning of the case, I think it's a certain amount of days after there's an answer filed or something like that. You're required to go into a mediation, and it could be a time limited one, 2-hour mediation, something like that, just to see if there's a chance after looking at the disclosures that the parties can come to some arrangement. If not, off you go to the races, and then you do it the old way, like after, at the dispositive motion deadline, you're required to mediate, have the regular mediation after everybody spent lots of money, has been entrenched, really mad at each other. And, the reason why,
Spent a lot of money.
right. And a lot of times the reason people settle there is that one party or the other is going to cry uncle and say, okay, I can't do this anymore. And then, it's not exactly even though people say a good settlement is one where everybody's not happy with it, you don't want them being totally turned off the court system. And that happens a lot. They go through all this, they mediate at the very end of a case, they spend lots of money, and they come out of the court system going, that was a total waste. That was a money pit. Our court system is a money pit. And then later on, people don't have, respect for the rule of law because they think the whole system's, stacked in favor of lawyers or something, name your rhetoric regarding that.
Mhm.
And so it's something to think about. I think is, trying the right after initial disclosures, a short mediation, and see where that leads.
Well, it seems like you're advocating for what's known in the industry as early dispute resolution. So, getting together much earlier to avoid the money pit, as you say, because the legal system sometimes has its inefficiencies. Um, and always the question, the debate that will be ongoing, even with early dispute resolution, is how much do you really need to mediate, right? How much information, how much time do you need to spend? Do you actually need to know everything with certainty before you can actually settle?
Yeah, for instance, I don't think so. Number one, the parties know their dispute better than the lawyers do. They've been living it, right? They usually, by the time they go to the lawyer, the dispute's been going on for a while. It's not like, you have a dispute today, you hire the lawyer, you sue tomorrow. So normally they've been at it for a while. And so that's why I mentioned doing this after initial disclosures. So there's some information. You have to disclose the witnesses. You have to disclose what documents are available. You have to disclose. It's almost like doing like an arbitration pretrial, pre-arbitration order where you list witnesses and the documents that would be exchanged, and then what your damages are, and in what method, and if there's insurance. And so in a way, it's almost like what you see in arbitrations, like in a preliminary disclosure order. Arbitrators sometimes will issue, is that kind of information, and from there you can at least have an intelligent conversation as to, because you might see in the disclosures a witness list going, who's this? And then you find out, well, that's the witness that totally tubes your case, right? so now you're a little more amenable to settlement, and so.
But that's at the very end, right? That's
yeah. Then you find at the end it's too late, right? You're in. I mean, so if you know it at the beginning, I think at least that preliminary initial disclosures give you enough information, at least to do a short mediation. To at least, and sometimes it's just meaningful just to have a short mediation, and people just air out their problems or issues, and sometimes that results in the parties organically settling.
fantastic. So let's settle into one of my favorite parts. Your top 3 tips for better negotiation outcomes. So you've spent 30 plus years doing your work in high legal pressure environments. What could you give our listeners in terms of the lawyers, the mediators, and business professionals that deal with disputes? Your top 3 tips for better negotiation outcomes.
Number one is managing client expectations as to what is really not possible, what's probable, right? I mean, because a lot of times they'll have unreasonable expectations going in. You're never going to go to a mediation. You have a claim for $500,000. The other side's not going to make a first offer of $500,000. And they probably won't make something even remotely close to it. But how many times do you see mediations where the one side makes an offer and the other side's completely insulted and wants to leave, right? Happens all the time, right? So managing expectations right there to have a fruitful mediation is, what is probable, what could happen. I mean, you might not settle, but at least, coming in with an open mind, with all the different, possibilities. It's good to brief your client ahead of time. You often will do, you do a mediation memo for the mediator. Should, talk to your client about it. Like, this is what's good in our case. This is what's bad in our case. This is how much it might cost. Let me tell you, make sure they understand how this is all going to play out if it doesn't settle. So they have a clear understanding of what may be in their best interests.
A pathway. Right? A runway, where you're going.
Yeah, absolutely. Right. That kind of thing. Number 2 is knowing your audience. And what I mean by that is the other side. We talked a little bit about it already. What's their pet peeve? I mean, this guy breached your contract. Why did they breach it? Did they breach your contract because they're just incompetent? Sometimes, yes. Other times, did they have a problem with the quality of your product? So they didn't pay the bill. We were very late in delivery, and because of that, they lost a customer, right? And so knowing that, the reasons why, there's a million reasons why people don't pay their bills, that isn't always that they're just deadbeats. It's, there are other issues. And so you need to be able to, in mediation, be able to address those issues. It's a quality problem. Okay, let's talk about the quality problem. Would be able to settle this if we gave you a discount on a future shipment. Would be, just talking creatively. Sometimes you have to be out of the box rather than, once again, just offering money, offering some other way. Can these parties continue to do business? So ultimately, people want to do business. They want to make profits. So is there some way out of this dispute that can be profitable for both sides? And so it's really knowing your audience, managing expectations. And then the number 3, we talked about this already, looking at how this is going to play out includes, when you get the trial, how are you proving your case or your defenses? You got to have that sculled out in your head because, otherwise, even at mediation, you're not going to be really prepared to address some of the issues. The other side, tells you something, and you can say, well, if you know the case in and out, how are you going to prove that? Are you bringing that witness up from Tierra del Fuego, which forensic experts you going to get to prove that third party computer system wasn't hacked, or whatever, those kinds of things. And that sometimes can give a realization to the other side that their case is going to be much more difficult, whether they're right or not, to ultimately prevail in court. So it's those are my main points.
All very excellent. So, Bob, this has been an extremely useful and basically a masterclass in international law negotiations. So, thank you for that.
Appreciate it.
For anyone that's listening who wants to follow your work, learn more about you, or connect with you professionally, where should they go?
Well, you can go to my website, www.rjbecerralaw.com. It's Robert J. Becerra, so it's rjbecerralaw.com. Our Becerra Law was already taken as a domain, so I had to do it that way. So, if you go to my website, you'll learn all about my background. And on Google my name, you'll find me.
Okay. And are there any other things that you would like to promote or you're working on that people should know about?
Yeah, I mean, I am running for the seat 5 for the 11th Circuit on the Florida Bar Board of Governors. That's one of the Miami representatives on the Board of Governors. So people don't know, the Board of Governors is like the Congress of the Florida Bar. It's the people who make the rules of professional conduct. They're the ones who budget the bar, administer the bar. They give advice to the legislature on laws and bills that are pending and things like that. So I'm running for the Miami seat on that. It's a 2-year term. Voting ends March 15th. How do you vote? Miami lawyers, go to your Florida Bar portal. Your portal on the Florida Bar, you put your user ID, your password. It's the same place you input your CLE hours after you get CLE. And on the left-hand side of the page, when your pretty face pops up, you'll see a button that says vote, and the ballot will come up, and that's where you vote for me.
Very good. And to our listeners, thank you for joining us on the Meaningful Mediation podcast. This episode has added value to your practice. Please subscribe, leave a review, or share it with a colleague who could use it. Thank you so much, Bob. It's been a real pleasure.
I thank you. It's been fun.
We hope you enjoyed this episode of the Meaningful Mediation podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.